little
Yeah.
bit about your board. That's an interesting fact about SoundExchange that I think a lot of people don't necessarily realize.
Yeah.
So SoundExchange started out as basically a division of the RIAA, right? I mean, way back,
Right.
the eight-ish.
Yeah.
And then around, I think, 2002, if I remember right, it got rolled out.
2003. Yeah.
2003, it got rolled out as a
Mhm.
standalone
Yeah.
nonprofit. And at that point, um, they set up the board and talk about the board a little bit. It's unique among these
Yeah.
organizations, really.
Yeah, it is. So just a little bit of context for SoundExchange, and I apologize if this is material that you've already covered, but SoundExchange, as Chris mentioned, we were initially housed within the RIAA, spun off in 2003, and we are within the statutory license in sections 112 and 114. There is a need for a collective to collect the royalties paid by all the different statutory licensees, and then to distribute those royalties out to the recording artists and the rights owners. And in each copyright royalty board proceeding, besides arguing for higher rates, we also have to present our case for why we should be redesignated each time as the collective. And so one of the ways that one of the many things we point to as a basis for redesignation is that we, faithfully and accurately and authentically reflect the the constituencies that we pay. And that is most directly reflected through our board. So we have an 18-member board, and the board is comprised half of representatives from the recording artists. And those can be artists themselves. It can be managers, lawyers who work on behalf of the artists. And then the other half of our board is the rights owners. And so those are representatives of the labels. The three majors have seats on the board. We have a couple of other rotating seats. We have the RIAA has a place on the board. The A2IM, the Independent Record Label Organization, has a seat, and then there are specific independent labels that also have seats on the board as well, and those seats all rotate. And so we have to be responsive to both equally to both the recording artists and the rights owners, and that's a very important thing to emphasize. When the statutory license was first created in the late 1990s, what it was trying to solve was what to do in a new world where streaming was becoming more prevalent, and sales were declining, and especially precipitously declining as more and more people were using services like Napster to share music rather than to buy. And Congress generally does not like to take up bills related to copyright or to the music industry unless all the stakeholders have bought in already. And so to get the statutory license set up by Congress and adopted by Congress required the buy-in not only of the rights owners, which is what copyright law is typically focused on, but also the recording artists, and that was a big deal. And so, in order to ensure that the statutory licenses were passed and adopted by Congress, one of the key features was that there had to be representation not only of the rights owners but also of the recording artists in the process. And so, to this day, we continue to be responsive to both sides. And when it comes to growing the pie, the interests are by and large aligned. But there are times when the interests diverge. Rights owners, record labels in particular, and the majors in particular, they come from a tradition of being the organizations, the entities that receive the royalties, and then they account to their recording artists according to their artist contracts. And in the statutory license, that that mechanism it doesn't exist. Instead, artists are paid directly by SoundExchange, and the royalties are essentially split 50-50, with the rights owners getting half, and then the recording artists getting 45% directly as the featured artists, and then 5% going to the unions for distribution to the backup artists. And so the rights owners are typically accustomed to getting more than 50%, and then basically getting the entire royalty stream and then accounting to their artists. And so we thread the needle there and we do so because of the equal representation on our board.
And that was a major point
Yeah,
when SoundExchange was first set up, was the
yeah,
passing through the artist share on a non-recoupment basis. That
that's
was
right.
a big deal.
That's
And
right.
it had a lot of, I'll say it so you don't have to, it had a lot of resistance
Yeah, that's right.
from the labels. That was not a popular thing. And I always felt sorry in the very beginning of SoundExchange. I always used to say SoundExchange, when in the first few years before it rolled out, was basically John Simpson and his dog, sitting in an office at the RAAA, surrounded by people who wanted that money, right?
Yeah,
And God bless him, he held out.
yeah.
And when it finally rolled out, it was a good thing for everybody, I think.
It's been a
Uh,
really big deal because, like,
yeah,
when
yeah,
I joined SoundExchange, the I can't remember exactly the annual distributions, but so I joined SoundExchange in 2010, and I think it- we were distributing on a quarterly basis, and I think our quarterly distributions at the time were about $40 million. And
right.
so it was like 150, 160 million a year, maybe 200. And now we're consistently distributing $1 billion. And so what John and others, Mike Huppy and others set up back then has really flourished since.
Yep. Yeah, no,
Yeah.
and the other thing you have to remember is that when this statutory license was created, it wasn't trying to fix something after the fact, right? Like
Mhm.
like the mechanical license was. The webcasting license was for an industry that did not really exist. I mean, there were some, of those music services that are way down on the, cable dial that you never listen to, right? There were those.
Yep.
But there really wasn't a Pandora. There wasn't, a simulcast, where you have the broadcasters involved, and it just didn't exist. And the main reason it didn't exist is because there was no performance right for sound recordings. So
Mhm.
there was no royalty. There was no license needed, right?
Yeah.
In order to play records on the radio. But that all changed. And once this became available, then it actually did create a whole industry. Would that industry have been created otherwise? I don't know. I doubt it, because it would have taken a lot of effort, to license all those different sources. But because there was a statutory license available, it allowed things to move forward. But it started from the beginning, right? So you didn't have to deal with what you have to deal with now with AI, for example. If you were to create a statutory license for AI, you've got this backlog of what do I do with everything that's gone wrong so far. You didn't have that in those days. And
Yeah, it's fascinating. Like we in our little slice of the industry, we talk about the pre-existing services,
right,
the services that were around prior to the passage of the act in 1998 that set up the first version of the statutory license. And there's only two pre-existing services, Music Choice and Muzak. And like you say, everything else has developed since then. The statutory license, we like to refer to it as the easy button, because it allows, like, we've gone from two services that were streaming music, like you said, through the cable boxes, to now, like, SoundExchange collects royalties from more than 3,500 different statutory licensees. And a lot of them are the broadcasters that are simulcasting. And that's a big part of the volume. But you're right, like, if without the statutory license, then each of those 3,500 services would have had to negotiate licensing deals with all of the rights owners, and not just the majors, but everybody.
Everybody.
And you just
See,
think about
that's the
the
problem.
number of rights owners on one side and the number of services on the other side, and you'd have to multiply those two numbers to determine the number of transactions that would have had to take place. And instead, these services just pay their royalties and report their usage to us, and then we distribute the money out the door.
And I can guarantee you that what would have happened is that if there hadn't been a central place to do the accounting and to send out checks, there, to the extent you ever did get a statement, if you had to do it as piecemeal, that
Mhm.
statement would go in the corner of the counting house and somebody would eventually get around to it. It would come in, maybe
Yeah.
on tissue paper, on, Excel spreadsheet, on, notebook paper, with child, paraphernalia stained on it. It would come in all kinds of different ways. It wouldn't be standardized at all. And it would never get out. So to the extent that the money ever did come in, it would probably not ever go out. It would be the Roach Motel of all time. But because
Yeah.
somebody had the foresight to actually start SoundExchange, and you had people like John and Mike, to who were there to make sure that this actually did happen, that the database actually did get built, that statements actually did go out, and they held the line against the labels trying to take the money. Um, it's now flourished into this $1 billion a year deal, which is actually pretty cool. And just
Yeah, that's right.
to go over the law real quick. So remember, there's no, and we're going to talk a little bit about AMFA and the performance right in sound recording, but for years, there was no performance right in sound recordings at all. And then in 1995, Congress passed the Digital Performance Right in Sound Recording Act, which became basically Section 114, and more specifically
Hmm.
114G, which is kind of the world that SoundExchange lives in. And then in 1998, as an amendment to the Copyright Act that was mostly DMCA, what we think of as DMCA, we also had um, the statute that actually created SoundExchange and created the financial part of the license as at least a revenue split and a method for determining what the royalty ought to be. So that's how we kind
Right.
of come to be here on the law. Now, 112 was the ephemeral copy, and that's kind of been subsumed into the 114. It's always called 114 and 112, but it's actually one rate now, right? It's no longer a separate rate.
Yeah, that's right. So in these rate proceedings, um, the copyright royalty judges are tasked with setting a royalty both for 114, which, as Chris mentioned, is for the performance of the recording, and then Section 112 is for the temporary copy, the ephemeral copy that facilitates those transmissions. And the to the in the view of the digital music services, as Chris said, basically 112 is subsumed into 114. The services pay one rate. And then it's SoundExchange's job to distribute and allocate those royalties and distribute them out. And what the judges have typically done is to say that of each dollar that comes in from a webcasting service, 95% of it is the performance right, and 5% is the ephemeral royalty. Um, and so we allocate 95% to 114 and 5% um, to 112, with one big exception, which is like we talk most of the time we spend talking about webcasting, we talk about satellite radio. And those are two of the most important categories of license types under the statutory license. But there's also the business establishment services, and those are the services that pipe music into bars and restaurants and the like. And in that situation, there is no performance right in the United States for those circumstances, and there's no general performance right. And so the royalties that we collect from the business establishment services all go toward the ephemeral, to the reproduction. And where that matters is this: the um, the, the performance royalties, as I said earlier, are split 50% to the rights owners and 50% to the artists. But when it comes to the 112 royalties, 100% of those royalties go to the rights owner. And it's my understanding this is, uh, one of those things that has been relegated to the dustbins of history. It's my understanding that the logic behind it is that the artists participate in the performance, and so they should participate in the royalty stream of the performance right. But when it comes to the reproduction copy, that's a more traditional right under the Copyright Act. There's a copy, and so those royalties ought to go exclusively to the rights owners. And that's like, I think that's an anachronism to of history. And there's a lot of people would say today that the um, the recording artists ought to participate in the ephemeral royalty stream as well. But to this day, it remains the case that all of the 114 royalties are split equally, and then the 112 royalties all go to the rights owners. And it's not that much money. Again, it's 5% of the pot. So I query whether it's worth quibbling over, but that's a unique characteristic of the regime that we're in.
That's a record deal point.
Yeah.
Pay me out of the record deal. So,
Yeah.
and just to be clear, what we're talking about here is the limited performance right of sound recordings and non-interactive services.
Yeah.
You want to say a little bit about the difference between an interactive and a
Yeah,
non-interactive? Mhm.
for sure. And it's a hugely important thing, and it's really relevant to the rate proceedings that I work on. So non-interactive services are generally understood to be those services where the listener cannot select the next recording that she's going to listen to. And whereas interactive services are ones that provide that kind of functionality, where you can select on demand what you want to hear. And this was the line between the two has been generally accepted for a long time. Now, the current 115 litigation involving Pandora will be really instructive on this. But ever since the Launchcast case in 2009, it's it's been generally understood that which services are non-interactive and which services are interactive. So, by way of example, SiriusXM is a non-interactive service. iHeartRadio generally is a non-interactive service. The AM/FM broadcasters that simulcast online are non-interactive. Music Choice and Muzak, those services that pipe music through the high-numbered cable channels on your cable TV or satellite TV package, they're non-interactive. On the other hand, the Spotify, Apple Music, Google Play, YouTube Music, those are the quintessential interactive services. And uh, and where this is relevant to the Copyright Royalty Board proceedings for 114 is this. When we're setting the royalty, when the judges are setting the royalty rates for sections 112 and 114, the one of the most prevalent ways that parties such as us argue for why our rate proposal is correct is we use benchmarking. And think of benchmarking as it's like the comparables in real estate. And so what you want to do in these rate proceedings as a party is to persuade the judges that your comps, your comparables, your benchmarks are better suited to answering what the rate should be than the other side's benchmarks. And so we, SoundExchange, have typically looked at the interactive deals as the appropriate benchmark, subject to some very important adjustments. But because the 114 license is available only for non-interactive services, it's not available for interactive services. Interactive services, Spotify, Apple Music, etc., they still need to negotiate directly with the rights owners, with the labels. And those licensing deals become the benchmarks in our proceedings. And we definitely have to make adjustments. Whatever the rates are in those interactive licensing deals are not going to be the actual rates that apply in the non-interactive setting. The fact of the matter is that interactivity is valued more by the consumer than non-interactivity. And so it stands to reason that the non-interactive rates would be somewhat lower than the interactive rates. And so that's an important adjustment that we have to make, and how to value what uh, interactivity versus non-interactivity is worth. That's a difficult thing to quantify, and that's why it's one of the reasons that economics experts in these proceedings get paid a lot of money. And so that's one way that the interactive um, services are relevant in our non-interactive rate proceedings. The other way that they're relevant is this. If for anyone who subscribes to Spotify or Apple Music, the quintessential terms of those are like lean forward services where the listener is actively selecting tracks, versus lean back, which is when you're just turning on like a radio like service and just listening to whatever is played without really influencing what comes next. Um, Nevertheless, in practice, a lot of listeners create playlists on these interactive services like Spotify. And so what we talk a lot, one of the themes in our cases is we talk a lot about convergence and how the interactive experience and the non-interactive experience are converging. And the importance of our saying that is it makes our benchmarking approach, we believe, to be more relevant. And so when we are relying on the interactive deals as the basis for our rate proposals, we talk a lot about how the listener experience for non-interactive and interactive actually is growing closer and closer together. So the distinction between interactive and non-interactive is hugely important because it gives us source material to work with for sending our using as benchmarks in our rate proceedings. But the line is also converging between the two.
And the other thing to remember about interactive versus non-interactive is that there's no streaming mechanical on non-interactive. There is a performance royalty
Mhm.
that's payable on non-interactive. So they still have to go to the PROs and get their licenses for the songs, but they don't have to pay a mechanical license. There was a
That's right.
reason for that. I'm sure I knew it at one point, but now it's just kind of the way it is. Yeah, I don't remember why that is. I'm sure David Israelite had a
Yeah.
very expansive, explanation for why. Um,
Right.
but I don't remember what it is. Do you? I don't know. But I do know it's not payable. So the
Yeah.
PROs end up, I think the benchmark or the back of the envelope number I've always used for that is like basically 5% of an adjusted gross, something like that in the aggregate, right? Because remember, you've
Mhm.
got ASCAP,
Right.
BMI, all these people have to go to each one of these PROs. So in the aggregate, I think they work out to about something like 5%,
Yeah.
which
And
I'm
so
sure
the on
complain.
the uh, yeah, on the so for the, that's 5% for the musical work, and then the on the sound recording side, it's a bigger a big multiple of that that gets paid through, and that can be a source of contention between the publishers and the record labels. Our view is has always been that um, each each side, the publishing side on the one hand and the recording side on the other, ought to be able to, advocate and get whatever they can get. And that is in contrast to a lot of digital music services would prefer just to write one check, and
Right.
then the music industry in total can, fight among themselves over who should get how much, and that would not be healthy. It would be a difficult thing to do. So, the current state of play is that, the publishers ought to advocate and get for whatever they can, and likewise on the recording side, and we try to stay out of each other's ways. But I think the digital music services would love to put us in the same room and make us fight it out among ourselves.
Question?
Yeah, so you talked to us last time about the CRB, but like, can you talk about how those like negotiations actually look? Does it look like an arbitration where the parties are like all hanging out in the room talking it over? Like, I know it takes a while, but how does it look when they actually communicate?
Well, my impression of, and I'll say it my impression of the way the CRB looks is it's something like a boys' gym in Oklahoma. You come in and there's, stacks of things and the judges are sitting up on some kind of riser with robes on behind lunch tables, is the way it looks to me. But Brad, why don't you tell us, since you're the one that actually does this work, what's the story there? What's the experience of going to
Yeah.
the CRB?
So if it's okay, I'm going to share my screen for just a second
Sure.
because I've got a one little timeline graphic that might be somewhat useful here. I'm going to request, Chris, if that I can share, if you could accept that request. All right. And so I'm going to try to share. I think this is the right one. All right. Can everybody see this timeline?
Yes,
Actually, no.
you should go in that.
I'm gonna change it to a different one. Yeah, this one. Okay. Um, Perfect. Okay, can everybody see that? Or Chris, can you see that?
Yeah, we got it.
Okay.
You should
All
probably
right. So I think
better view
yeah.
because it's kind of small.
Fair enough. One sec. Um, there we go. And all right, is that better?
Yeah, that's much better. Yep.
Okay. Great. So I think the question was, what do these CRB rate proceedings look like, and what is how do negotiations work in effect? And so basically, these rate proceedings take 2 years, and what I've got on the screen here is the timeline for the most recent rate proceeding, which is webcasting 6. We number our rate proceedings as if they are Super Bowls. And so, and these proceedings set rates for 5-year terms. And so, for example, Web 6 started in January of 2024. It should have ended in December of 2025 with the judges issuing their determination. And it's setting rates for the period 2026 through 2030. So they're two-year periods to set rates for a 5-year term. And initially, the proceeding starts with the judges posting a notice in the Federal Register soliciting petitions to participate from the parties. And so we file our form to participate in the proceeding. Soon thereafter, the judges will issue their case schedule and also announce the beginning of the voluntary negotiation period. Now, the voluntary negotiation period is 3 months. Never has there ever been a settlement that has occurred in that period. And here's why. It takes a really long time for parties on both sides to figure out what they think their case ought to be. And once it's only after the parties have a good sense of what they think the rates ought to be, that settlement discussions are actually useful. And the nice thing about the voluntary negotiation period is that, you know, parties are not required to settle during that period. We can settle at any time. And in fact, in Web 6, we still don't have a decision from the judges, but we, SoundExchange, have reached settlements with 4 different groups of parties on the other side. And we reached a settlement in September of 2024. We reached 2 settlements in April of 2025 on the eve of the hearing. And then we reached another settlement back in November, a couple months ago. And so, as you can see, we can settle at any time. It's no surprise that the first settlement occurred in September of 2024 because that's right before the first big milestone in these cases, which is when the parties file their written direct testimony. And and so that's the big milestone. That's when the parties um, filed their initial rate proposal. They also filed testimony from their fact witnesses and testimony from their expert witnesses. And so in September of 2024, we filed testimony from about a dozen fact witnesses and three or four expert witnesses. Um, that from there, the the parties enter the initial the discovery period, and the rules of the CRB. Um, the parties can take up to 10 depositions. They can serve up to X number of interrogatories, and then, of course, they can make innumerable document requests. And then after going through that process, the parties are more or less prepared to write the rebuttal testimony. And of course, rebuttal testimony needs to respond to the other side's initial direct testimony. After rebuttal testimony is filed, then there's the rebuttal discovery period. And all of this leads to the hearing that generally takes place in the spring of the second year of the cycle. So for Web 6, that was in April, May of 2025. Since the pandemic started, prior to the pandemic, the Chris's description of what the hearing looked like was pretty apt. We were all crammed into a tiny little room in the Madison building of the Library of Congress, just south of the Capitol building, and it was windowless. It was makeshift, and it was basically being in a glorified conference room, the or not so glorified conference room. Since the pandemic, the hearings have been held via Zoom, and uh, there is some pros and cons to it, and it's worth discussing. On the one hand, the obvious downside is that the cross-examination is less effective of the witnesses. Also, the judges are deprived of completely being able to evaluate the credibility of witnesses. There's a lot to be said for body language and observing body language, and that's generally lost over Zoom. Um, the there are two upsides to these virtual hearings, and those are these. One is that in the in-person realm, um, both sides typically have to schedule their fact witnesses and their expert witnesses based on whenever the witnesses are available. And what it means is that sometimes the testimony goes in a non-sequential, disjointed manner. Whereas when you're doing it over Zoom, witness availability is a lot less of a problem. Like there's no need for witnesses to travel to Washington, D.C. And so both sides can sequence their witnesses in the way that they think best presents their case. The other upside to the virtual hearings is that in the in-person world, if a witness was still on the stand on, let's say, Friday afternoon, but was not yet off the stand, then the witness basically would have to stay in over the weekend in Washington, D.C., and then resume testimony the next Monday. And that's disruptive to the witnesses. It's not cost effective for the parties to host witnesses for in hotels over the weekend, and et cetera, et cetera. And so all those problems are solved with virtual hearings. I think by and large, even though there are some pros to the virtual approach, I think by all sides and the judges would prefer to be in person and be able to um, observe the witnesses in person. I think it makes the examinations, both direct and especially cross-examinations, a lot more effective. The newest rate proceeding is the one that is commencing now that will set the royalty rates for satellite radio. And we're currently discussing with the Copyright Royalty Board staff on whether we can have an in-person hearing in about a year from now. Unfortunately, the the hearing room that was once used is no longer available to the CRB, and so it's an open
Too
question
much storage,
whether.
is that it?
Yeah, probably.
Too many file boxes?
Too many boxes. So we'll see what happens. Um, I think the other part of the question was to talk a little bit about more about the negotiations, um, and that's worth discussing. So um, the uh, as I mentioned, we settled with four different parties, and three of those parties were non-commercial, nonprofit webcasters. So we settled with the public radio broadcasters, which we typically do. There's not a lot of money there, and so it just makes sense to settle those. We also settle for the same reasons with the educational webcasters, basically the college radio stations. And then the the other non-commercial settlement that we did, that was the one we did most recently in November, was with the biggest religious broadcaster out there, which is Educational Media Foundation, which is also known as KLove, and that was an important settlement to get done. And then on the commercial side, that's always a little bit harder to settle because there's so much more money at stake. And believe me, these rate proceedings, these litigation costs are, and we're talking eight figures. And so you would expect that given the cost of litigation, that the incentive to settle would be very, very high. Um, of course, even though the litigation costs are in the eight figures, the amount of royalties that are at stake are in the nine figures. And so that makes it much more difficult for us to settle with the commercial services. But we were able to do a settlement for the first time in a very, very long time with the National Association of Broadcasters and their AM/FM broadcaster constituents, which was a really big deal. Um, and it's worth talking a little bit about how those negotiations work.
So
Um, for
before you do that, these are different
Yeah,
rates, right? The, the rates that you get from the non-coms are less than what you get from the commercial. Is
yeah,
that,
that's an important point to make, an important distinction.
yeah.
The
Used
non-commercial
to have
service, like
webcaster settlement acts, right? That would allow you to do individual settlements based on the business model or the bargaining unit. Is that right?
yeah, so these days, like the Webcaster Settlement Acts were hugely helpful for reaching settlements through the end of 2015, but those acts have since expired. And so right now, when we do a settlement, we need the copyright royalty judges to adopt it and approve it, and basically publish it for public comment, and then decide whether to adopt it. And like you said, Chris, for the non-commercial webcasters, um, the rate structures are just different, so they're not comparable to the commercial services. Um, for example, with the public radio stations, um, the we receive a flat fee each year. We have and we will continue to receive a flat fee each year on behalf of all public radio stations, and that historically was paid to us by the Corporation for Public Broadcasting. The Trump administration has effectively killed that operation, and so the payment obligation has moved to NPR, and NPR will pay on behalf of all the public broadcasters. Um, for the college stations, they typically they do pay, each station pays us a flat annual fee. I think it is $800 per station this year. Um, and they pay that to us directly, but they don't pay any additional royalties. These college stations are run by the students at each of the schools, and so we don't subject them to the task um, uh, of calculating how much they would owe for each performance, and then sending us particularized payments. So they just pay us an annual flat fee, and that covers them for the year. If they it covers a certain amount of usage, and if they were to exceed that certain amount of usage, then they would need to pay for the additional usage. But the threshold is high enough for college stations that they don't exceed it. And then for Educational Media Foundation, they likewise pay us a flat fee, and that's been hugely helpful. They have hundreds of stations, and under the non-commercial structure, there was a risk of of a big non-commercial service like Educational Media Foundation being able to game the system to some extent to reduce its royalty obligations, and a flat fee just takes the uncertainty out of it. Um, and in contrast, with the commercial stations, with broadcasters, the commercial broadcasters, they pay what is colloquially known as a penny rate. So they're paying per performance. And this year, the royalty rate is $decimal point 0028. So they're paying 28 one hundredths of a penny for each performance. And more relevant terms, they're paying 28 cents for every 100 performances. And each performance is defined to be the transmission of a sound recording to a listener. So if a radio station is streaming online one particular sound recording and 150 people are listening at the time, that's 150 performances. Um, so the in terms of how we reached that settlement with the NAB, um, I think that some of the most important dynamics to talk about here are that one, discussions really didn't happen in earnest until um, September of 2024, when NAB had put together its case, we had put together our case, and we had each side had a pretty good sense of what they thought the rates ought to be and why. And our rate proposal was that the broadcasters and anybody else making what are called non-subscription transmissions to pay 34 cents for 100 performances, and entity thought the rate ought to be 15, and so it's a pretty big gap.
They're
And
generous
so we started
people.
off with really, say it again.
I said they're generous people over there at the NAB.
That's right. And yeah, in fact, to contrast that with the status quo at the time was a rate of 24. So
Right.
we were trying to go up to 34. They were trying to go down to 15. Um, and and the, so that was the first important factor. Each side needed to understand the information, the data, the dynamics to determine what they thought the rates ought to be. And then from there, we had extensive discussions, and it was it was the classic example of like sometimes we take two steps forward and one step back. Sometimes we take one step forward and two steps back. Um, and it was only because of, and I give NAB's negotiating committee a lot of credit because there was a wide gulf to begin with. But we kept at it, and through those discussions, I think the most important takeaway was that through these discussions, each side learns what is really important to the other side, and that helps compromise. And so, for us, like if we wanted to get to a certain outcome, um, what what we learned through these discussions is that our way of getting to that outcome was troubling in some aspects to the NAB. And so, if you can figure out a different way or different ways to get to your desired outcome, and those ways address some of the issues that the other side has, then that gets the compromise to gets to a compromise, gets to an outcome that both parties can live with. And I'll give you an example. So historically, we have the judges have set a rate that's applicable to the first year of the 5 years, and then said the subsequent years rates will be set according to changes in the consumer price index. And through the discussions, we learned that NAB really did not want that uncertainty, that they wanted to know what the rates would be for each of the 5 years. And so and we would have preferred to let the rates float with inflation because that keeps the value of the use of the recording consistent over time. But if they wanted certainty, then we were willing to go to um, a, uh, a a a rate schedule that was defined. And so what we ultimately agreed was a rate of 28 in the first year, and then it went up by 1 point each year, 29, 30, 31, 32 in the fifth year. And the the other some of the other aspects that were really important in the eyes of the broadcasters was uh, the late fee rate, especially when audits are conducted. We conduct audits of services from time to time, and those audits can take a long time. And if there's an underpayment found through the course of the audit, then late fees apply just like they would apply to any other late fee. And the broadcasters were really concerned that the late fees, the interest, would accrue to a significant extent over the course of an audit being conducted. And so they were willing to give on a higher rate in exchange for a lower late fee rate in audits. And we were, from our vantage point, we much preferred having a higher royalty rate and a lower late fee rate in audits. And so we were willing to give on that. But it just took so many discussions over and over to figure out what it was that the other side was really interested in, and then find a way to still get to the outcome that we desired, and do so in a way that gave them something that was of value to them, and got us something that was of value to us.
Excellent. Well, that's
Yeah.
that's kind of the name of the game, Now, are these people, do you see sort of the same faces year after year, just in terms of the actual people who are doing the negotiating, or do they change up the law firms? Because you're dealing with law firms
It's
all
it
the time, right? Or at least
it is, yeah. So great question. So the National Association of Broadcasters typically uses Latham and Watkins. Um, Sirius XM and Pandora use Weil Gotshal. Um, the um, the non-commercial religious broadcasters typically use a uh, a smaller firm here in the DC area called Fletcher, Heald and Hildreth. And SoundExchange, we've used a variety of firms over time. We've used Jenner and Block, we've used Munger, Tolles and Olson, and we're currently using Milbank. And so we definitely change more than the service side does. The Typically yeah, the faces are typically the same. So much value is placed in the institutional knowledge that these lawyers have from prior rate proceedings. And so that generally um, uh, means that it's the same faces over and over in these proceedings. And even though we've changed firms from time to time, I've been doing these rate proceedings since 2010. And I like to think that one of the reasons I'm still gainfully employed at SoundExchange is because I have the institutional knowledge from each of these proceedings, and that's my value add. So yeah, it's a typical cast of characters. Now for the copyright royalty judges, those we have three judges, and by statute, one of the judges is the chief judge, and he or she is required to have expertise in basically civil procedure and adjudicating disputes and ruling on objections and things like that. And then another judge needs to be an economics expert, and the third judge needs to be a copyright law expert. The chief judge has changed relatively frequently over the last few years, and in fact, the uh, the the incumbent chief judge stepped down in April of 2025, right before the Web 6 hearing was scheduled to begin. An interim chief judge was appointed, and then she stepped down in December, right before the determination was due to be issued. And a new interim chief judge was appointed, and that meant that we had to go back in front of the judges and have a second round of closing arguments for the benefit of the new judge. And it also means that even though by statute the judges should have issued their Web 6 determination by mid-December, so that the rates could take effect January 1, that hasn't happened, and we're still waiting for the Web 6 determination. So it's a really good thing that we have settlements in place with so many parties because we can move forward in the meantime. But it would be great to have as soon as possible that decision from the judges because the settlements that we reached don't cover everybody. They don't cover the subscription rate that services like Pandora and SiriusXM need to pay. And so for now, we're in limbo on that. They're still paying. They continue to pay us right now based on the requirement in the statute that they pay at the 2025 rates. But we'd like to know what the actual rates are going to be.
And that's the last
Um,
rate.
so
That's the rate of the last year of the prior rate period. Is that how that
that's
works?
the rate of the last year of the prior rate period. Exactly right.
Okay.
And 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 so even though there's been instability with the chief judge role, the role of the economics expert on the panel has been filled by Judge David Strickler
Right.
for I think it's like 12 or 13 years now. And so he's like when we're advocating in front of the panel, we're speaking to him the most. We fashion our case strategy with him in front of mind. And I'll give you you all just an example of one particular issue that we are hyper focused on because of the emphasis that Judge Strickler puts on it. Judge Strickler believes that correctly that the Copyright Royalty Board is tasked with setting royalty rates for the non-interactive marketplace as if it were a effectively competitive market. Effectively competitive market. He's correct on that standard. Where we differ is that he believes that our benchmark market, which is the interactive agreements, is not an effectively competitive market, and therefore he must adjust downward even further the rates from those benchmark agreements to set the rates for the non-interactive agreements. We don't think that's necessary. We think that the interactive marketplace is effectively competitive. Judge Strickler believes that because the license agreements are dominated by the three majors, that they are effectively a complementary oligopoly. And therefore, the major labels are able to extract royalty rates that are super competitive above what the market would yield if the market were effectively competitive. We disagree with that notion, and we point to the fact that the licensing deals that we most heavily rely on are between the major labels on the one hand, sure, but they're also on the other side, those are the deals with Spotify and with Apple Music and with Microsoft's music and with Google. And those are not companies that are bending to the will of the majors. These are massive corporations. And so whatever um, uh, market power the majors might have, it's counterbalanced by the market power that Spotify has, that Apple Music has. Um, we have not been successful in persuading Judge Strickler to our point of view on that issue. And we've in each proceeding we try to argue that both sides are um, uh, both the majors on the one hand and Spotify and Apple on the other have equal bargaining power. But if we can't, but we also argue that if Judge Strickler and the others continue to believe that there's an imbalance, then at least that imbalance has narrowed over time. And so with each proceeding, we're hopeful that the judges will take a fresh look at the facts and we'll see that, again, as time progresses, the whatever imbalance in power might have existed is growing smaller as time goes on. And therefore, the downward adjustment that the judges might feel they need to make should be less of a downward adjustment than it used to be. But it really matters. It's a very like who the judges are is really relevant to the outcome of these determinations.
Does Strickler pretty much have kind of unilateral control over this, or as in terms of at least the economic philosophy in
Yeah,
these
I think
decisions, or can he does he get talked out of it by, say, Steve Rue or somebody else?
Yeah. Yeah. So Judge Steve Rui is the copyright law expert on the panel. And it's always hard to tell. The way we can glean the most about what influence one judge might have over another, or how persuasive one judge might be with another, is through the questions that they ask during the proceedings. And Judge Rui, I you know again, just reading it seems to do a really good job of critical thinking for himself. I don't I, my sense is that he doesn't see the effective competition gap to be as wide as Judge Strickler does. Um, but to what extent that has helped us in prior proceedings to narrow the gap, it's really hard to tell. Judge Strickler is very incredibly thoughtful, and
No,
and he doesn't like he's willing to consider new information and new facts, but he tends to think that even with the new information and with the new facts, the situation is still more akin to what it was when he joined the bench for Web 4 back in 2014, I believe. And so it's hard to tell, is the short answer to your question. And especially given as with any institution, I mean, Judge Strickler's been there the longest by far. And so I'm certain that his viewpoints have a lot of value, a lot of influence.
and so the idea that they have limited terms is kind of a relative concept.
Yeah, this is so for the benefit of everybody, these judges are appointed to 6-year terms, but they can be reappointed, and I think Judge Strickler has now been reappointed 3 times. So if he finishes out his current term, he would end up being on the panel for 18 years. Um,
How
the
old?
Yeah, and the difficulty is that it's finding people who want to do the job of a copyright royalty judge. It's not it it's not a federal judgeship. You're not appointed for life. You don't have life tenure. You and the staff of the CRB is really small. And so you don't have the benefit of outstanding law students becoming law clerks for these judges. And the work is esoteric. And so the background historically for copyright royalty judges are that they come from state courts, or they come from federal bankruptcy courts, which are not lifetime appointments. Um, and it's not glamorous work. And so it's difficult to find candidates who are interested in these roles. And I think it's a big reason there's been difficulty in filling the chief judge role of late. But Judge Strickler just he seems to love the work. He's an economist. This is an opportunity for him to play a meaningful role in in shaping the economics of the music industry. And so he's keen to keep doing it, and it's hard to find somebody else who would want a job like this, and so he continues in the role.
We have a great article of his as part of the syllabus. He's a very effective guy.
Yeah. Is that his
Um,
uh he wrote he teaches at NYU, I believe, and he's written a couple of articles. Which one is on the syllabus?
it's the one that basically goes into the economic analysis of the CRB.
Yeah. Yeah.
It's pretty good.
It's very good.
So let's talk a little bit about AMFA. We want to wind down. I'm mindful of your time. But let's talk a little bit about AMFA,
Sure.
if you don't mind. One of as we've talked about this in class a bit, and I'm sure in their general knowledge, the students have run across this too, but one of the big bones to pick with the Congress is the absence of a performance right in sound recordings for terrestrial radio, which has all sorts of implications aside from just giving these broadcasters a free ride. So we've got the latest attempt at writing that is the American Music Fairness Act. So why don't you tell us a little bit about that and how that's going?
Yeah. So let me pull up one other document if I can find it in a decent amount of time. Um, one second. Uh, Okay. Yeah. So as Chris mentioned, um, in most countries around the world, there's a performance right in sound recordings when the sound recording is played over the air by AM/FM stations. And just to reemphasize, so far in this hour, when I've been talking about AM/FM broadcasters paying royalties, it's for their online streaming and not for their over-the-air, um, tower transmissions. And we estimate that um, uh, U.S. Recording artists and record labels lose out on about $200 million in royalties each year, and that's partly and that number is derived um, from a couple sources. One in particular is that there's so many all the other countries around the world that uh, collect royalties for the use of the sound recording by over-the-air broadcasters. They'll collect those royalties, and they'll collect those royalties for um, recordings by U.S. artists and record labels, but they won't pay those royalties out to the U.S. artists and the U.S. record labels because there's no terrestrial performance right in the United States. And so, under their theory of reciprocity, if their artists and rights owners are not going to be paid for the use of the sound recording over the air, then they're not going to pay our artists and rights owners for the use of the sound recording over the air over there. And so the U.S. music industry loses out on $200 million each year just because of that.
Yeah,
So this,
just to clarify that, so it's not that the stations aren't paying, right?
right, that
They
that
are
money is
paying,
sitting somewhere. Yeah,
right?
exactly.
They're just not
Yeah,
paying us. Yeah, right.
that money is sitting at the collectives in these various countries. That's for
Yeah,
sure.
yeah,
The and also it creates the fact that there's no terrestrial performance right in the United States also creates a distortion of the market, and where that uh, so that, like, for example, in these copyright royalty proceedings, I've talked a lot about how we take this benchmarking approach to try to determine the rates. Another way of approaching this question of what the rate ought to be is to do some economic modeling. And typically that's by looking at the opportunity cost to the record industry of um, uh, somebody like SiriusXM or iHeartRadio um, uh, streaming sound recordings. What would happen if they went away? Where would the listenership go? And in these surveys, so that's an input into an opportunity cost model. And so the way to quantify that input is to do a survey. And in the surveys, we need to ask like the question of where would you go if SiriusXM wasn't available? And one of the options is always I would just listen to AM/FM radio. That unfortunately drives down the opportunity cost calculation because AM/FM radio doesn't produce any revenue for the record industry. There's no terrestrial performance right. And so that artificially drives down the opportunity cost analysis. And that makes it more difficult for us to advocate for higher royalty rates on the streaming side. Um, the willingness to pay is always in the back, in the forefront of the minds of figuring out this question. And then, of course, there's just the issue of fundamental fairness. If clearly sound recordings have value, and typically in the United States, we intellectual property of any kind, whether it's books, movies, or music, ought to be compensated for fairly. And in this situation, there's no royalty being paid for the use of the sound recording in this on this one particular platform on AM FM radio. And so it just to recap, this problem means that we don't collect royalties for the use of sound recordings to a big extent overseas. Number one. Number two, it artificially deflates what the streaming royalty rates ought to be for non-interactive services. And then number three, it deprives creators of the compensation that they're entitled to. And so AMFA is intended to address this loophole. And what AMFA says, this is how the sausage is made. It says that for small commercial services, they would need to pay no more than $500 per year. For non-commercial services, they would need to pay no more than $10 per year. And then for the regular sized and big commercial broadcasters, they would pay at royalty rates to be set by the Copyright Royalty Board. Um, and so, like, proponents of the legislation, and we're clearly one of the proponents of the legislation, are willing to take a lower flat fee royalty from the small folks in exchange for getting what we hope to be will be a market rate on the from the bigger broadcasters. And the reason it's difficult to pass legislation like this, like I said at the beginning, for Congress to typically act on copyright related legislation, it needs to be nicely packaged. And all the stakeholders involved need to sign off. That's how the Music Modernization Act got passed in 2018. But with regard to the broadcasting, the terrestrial performance right, the NAB, the broadcasting lobby, is very, very effective. And in every congressional district, there are AM/FM broadcasters, and they have the ear of the representatives from each of those districts. Those representatives in each of those districts need AM/FM radio to reach their constituents and to run for re-election. And so it makes it more difficult to get this kind of legislation passed. We're with every effort, we're coming closer. And we had a hearing last year, and Mike Huppy and Randy Travis, and I guess that was 2024, testified in front of Congress in support of the of AMFA. And then in December of 2025, Gene Simmons from the band Kiss and Mike were testifying in front of the congressional committee. And Gene Simmons, I had the privilege of helping to prep him. And I have to say that guy does not stick to the script. And that can be both good.
A
Yeah.
tour de force performance, though. I'll tell you
It
that.
was. He
Yeah,
can say things that Mike cannot say.
yeah. If you
Um,
haven't seen that hearing, it's worth watching
it
because
is.
he
Yeah.
really lays it down as
Yeah.
only Gene Simmons can.
As only Gene Simmons can.
Yeah.
So we're getting closer and closer, and I I I sometimes joke that um, like AM/FM radio was hugely influential in promoting um, uh, certain sound recordings and certain recording artists back in the day. Um, no question about the influence in promotion that AM/FM radio has historically had. I think that influence has waned over time, and now listeners discover music in in so many other ways digitally, and AM/FM is typically a follower of the trends that originate elsewhere. And so I tend to joke that we will get AMFA passed, we will get a terrestrial performance right on the day that AM/FM radio no longer matters at all.
Right.
So, but it's important. I'm joking, but it's hugely important that we get this legislation passed. And it's been a long journey. It's been going on for a couple decades now. And we're getting closer and closer to getting bills out of committee, and the next step is to get one on the floor. And we keep hammering away at it.
Great. So, any questions? We're gonna wrap it up with Brad so he can get back to his day job. Yeah. Any questions? No? Okay. So we're good. Thank you so much for doing this, Brad. I really appreciate it.
Well, Chris, thanks for the opportunity. It was fun talking to you and to everybody out there in the classroom. It was nice to spend some time with you and talk about what we do here at SoundExchange.
All right, buddy. I'll talk to you
All
later.
right.
Thank
Take
you.
care.
Bye-bye.
Bye.